What you think about when you're born into a fire? Let them burn it out. Sell them to the richest buyer. They wanna let the world decay. They tell us lies and fade away, fade away. We feel betrayed. We were raised to lose the race. Wake at the back of the pack, kill it anyway. Listen up now, because we're never dropping out. Beat the odds, beat the big house. Our brains are bigger than the doubt. We've been thinking for ourselves, never let the truth fade away. This is bigger than ourselves, we won't let the world burn away, burn away. We feel betrayed. We were raised to lose the race. Wake at the back of the pack, kill it anyway. To blame, hate is face
Stop. There we go. All right, guys, this one's going to be shorter than normal. I'm just going to do the Phil thing and keep it separate from everything else. So let's roll the intro.
Hey Daddies, it's me, the Linda Binda from TikTok. I wanted to make this video because I wanted to thank you for watching Cold Beer Confessionals with Will Bird. I think that's just incredible. I've watched a few episodes and I'm just like very intrigued. But you know what I'm most intrigued in is Big Daddy's meat stick. I heard that it's very thick, like a good old German sausage. You know, Linda and her coochie loves that. Oh, never mind. Let's not go there. Anyways, I hope you have a good show and enjoy it as you can. There's a lot of weird things that go on, especially when it comes from the realm of Linda Bindaland. So, enjoy the show. Thanks for watching. Peace out.
Welcome everybody. I am Will Bird, and this is the Cold Beer Confessional. Thank you guys for joining us. Thank you for being here. I finally remembered where we parked. So I think I got it this time. We're going to do Phil Godlewski. We're going to watch his response. We're going to read the court document. And then we're going to watch the response again and see if those things go together. I'm guessing not. But Phil's got an excuse for everything, so we'll see how it works out. This is Phil Godlewski versus the Scranton Times. He took this all the way to the Superior Court of Pennsylvania. And he says in his response, I could take this even farther. What, the Supreme Court? You want the Supreme Court to tell you that you're guilty? But Phil claims that, oh, well, they didn't say I was guilty of doing that with a 15-year-old. What they said is there's no actual malice. And we'll see if that holds up. So here we go. This is Phil's response. He just mentioned this quickly at the first of his show the other night.
Things
to
go.
Back it
You're
up.
going to see me down here, but you're going to see the presentation up in the screen. A couple announcements to make before I get into that. I have been denied in the Supreme Court of Pennsylvania with my lawsuit against the Scranton Times. And although my lawsuit was the appeal, that was the appeal, of course, to get it out of Lackawanna County and into the Supreme Court. The appeal, of course, was to the higher court, the Supreme Court of Pennsylvania. And although I lost, and I'm not going to be recovering anything against the Scranton Times. Now, I could take this another level higher. I'm not going to. But because the manner in which I lost, I'm okay with. They didn't confirm.
I am a gigantic, well, I used to be. I don't watch sports as much anymore. But I was the biggest Virginia Tech football fan in the fucking world. So every time you mention Miami, I have to stuff down some like my it flashes red. I have to push down some rage into a special place where I keep it for later.
The Lackawanna County's ruling. They simply said there's no malice, meaning the writer of the article, Chris Kelly, has to purposely say the things he did while knowing they were untrue. That's called malice. When you're a public figure such as I am.
So what he's trying to play on here is that the statements were untrue, but Chris Kelly just didn't know that. And the only reason I didn't win this case is because I'm a public figure, right? If I wouldn't have been a public figure and the malice clause was thrown out, I would have won. He didn't even, we've seen his defense.
You have to
Come
prove
on.
malice. The Supreme Court said there's no malice here.
But to be fair, I mean, he is what he is, right? And he does what he does. And he's super fucking wealthy. He's basically retired, doing his own thing, living his best life. I mean, he's a fucking millionaire, right? Multiple houses, cars, Rolls Royces, everything you could imagine. Like he played the scam. He went from not a great real estate agent and part-time Subway sandwich artist to a multimillionaire.
So technically I lost on a technicality.
Just that technicality hanging him up.
But not because what the writer said was true about me.
I used to be. So, I was always like super rebellious, and we live in Tennessee, and my family was Tennessee fans. But I fell in with Virginia Tech. I had some friends that liked Virginia Tech. And I liked Virginia Tech. And then later on in middle school, I met another kid whose family, his parents went to Virginia Tech. And I was like a poor kid and he was like a rich kid. But his parents found out and we were friends or whatever. So they took me to a bunch of games and I became like a diehard Virginia Tech fan. His dad played football for Virginia Tech and his mom played, his mom did track and cheerleading, maybe? No, tennis. Track and tennis, I believe, at Virginia Tech. And I started hanging out with them and going to games. And, I became a huge fan.
Me, although it's not a victory, it's a accept, but not because what the writers.
Do you think him and Carrie are swingers? Like, there's way too much pineapple thing. Like, what is going on?
That was true about me. To me, although it's not a victory, it's a acceptable outcome. I am not going to pursue anything further against the Scranton Times. I am
Enter Sandman.
dropping my lawsuit against Nick Alvear just because I don't want to deal with this shit anymore.
Even talking about dropping the case against Nick Alvear. Yeah, they play Enter Sandman when they run in to Lane Stadium. It's pretty cool.
And we'll see what happens with the other couple. I know you guys don't want to talk about lawsuits tonight because we have a lot more important things to go and talk about. But the court system in this country is terribly flawed.
So I don't know if you guys remember this, but when I asked him for basically comments on the case or whatever, I would text him and be like, hey, you want to say something about this case that's coming out? This was months and months ago, not recently. But he would say things like, once it gets in front of the court, once the judge sees this, once the jury sees this, once this gets to the Court of Appeals, I have a slam dunk. There's no doubt I'm going to win. As soon as there's no way they could deny this. I'm going to win no matter what. Like, he had this uber confidence. Like, it was crazy.
And when I say terribly, I mean terribly. I mean, you saw what Trump went through. I just went through something very similar. And it's a joke. It's an absolute joke.
Him and Trump are probably more similar than he thinks because they're both guilty of what the media is saying about them. It's just Trump has the power to make people fold, and Phil picked somebody that wasn't going to fold. And he could probably win the Nick Alvear case. Nick Alvear won't even show up for his court case.
There is no justice when it comes to the media. There's just not. And I really hope that Trump can fix this, and it appears that he's, taking out the media every time we look around. By the way, before we get into the Charlie Kirk stuff, Jimmy Kimmel's fired, Matthew Dowd fired.
Jimmy Kimmel's back.
These are big things that are happening in the media, which is awesome, absolutely awesome. So
that's basically his response, and then he moves on with the rest of his show. Okay, that was from Shaq. If you follow Shaq over on Twitter or TikTok, all the places. All right, I've got the document. Let's read it. If you want to support the show, do that at buymeacoffee.com/coldbeer. As you help pay the bills there. All right, here we go. Ready? Filed September 15, 2025, memorandum. Appellate Phil Godlewski appeals from the order entered in the Lackawanna County Court of Common Pleas, granting summary judgment. So he's appealing this order that granted summary judgment for Chris Kelly and Scranton Times. The relevant facts and procedural history of this case are as follows. Appellate initiated this action asserting claims of defamation and false light invasion of privacy against the Palese. So Phil instigated this against Scranton Times based on a column entitled QAnon Realtor Sells Rabbit Holes on YouTube, authored by opinion editorial op-ed columnist Chris Kelly, and published by the Scranton Times on February 14th, 2021. Trial court opinion date was 8/30/2024. In the column, which the trial court quotes in its entirety, Kelly stated, inter alia, that appellate had previously pled guilty in Lackawanna County to corruption of a minor resulting from a sexual relationship with a 15-year-old student while he was a 27-year-old baseball coach at her school. That's the first claim, right? Sorry, something popped up. Okay. By the trial court, it says, see Commonwealth v. Godlewski by the trial court, appellant contends in his verified complaint that the article contained 3 defamatory characterizations regarding him. First, he maintains that Kelly and the Scranton Times falsely accused appellant of having a sexual relationship with a 15-year-old pursuant to a criminal matter which occurred in 2011, even though he never had sex with an underage girl, and pled to a misdemeanor. He avers that Kelly deliberately conflated the charges against appellant of having sex with a girl with his plea to a misdemeanor charge of corruption of minors, and claims that there is nothing in the appellant's criminal record which indicates, relates, or references to appellant pleading guilty to having sex with a 15-year-old girl or any other underage girl. Second, appellant alleges that by stating that appellant was selling rabbit holes on YouTube, coupled with a cartoon of a real estate sign on top of which was written rabbit hole for sale, and beneath the words unrealtor, and next to a diagram in the center of the sign that represents QAnon, Kelly and the Scranton Times gratuitously, maliciously, unnecessarily, and inextricably linked appellant's professional integrity to his alleged political views, using the latter to impugn his integrity as a realtor. He asserts that he made his reputation as a realtor by being trustworthy, reliable, and knowledgeable, and discharging the highest ethical standards, but was terminated by ERA One Source Realty because of the defamatory article written and published by Kelly and the Scranton Times. He submits that he has been defamed in his profession as a realtor, in which he functions as a private individual, and that he remains a private figure with respect to criminal charges which were brought against him, and any plea agreement does not transform him into a public figure in that respect. QAnon has been described in other litigation as an un-American conspiracy movement that centers around Q, who is supposedly a high-ranking government official who leaks top-secret information about the deep state. It believes that the secret global cabal of Democrats and celebrities worship Satan, sexually abuse children, and drink the children's blood to ingest a life-extending chemical called adrenochrome. QAnon is considered to be the progeny of Pizzagate, the theory that high-ranking Democratic officials were running a child sex ring out of a Comet Ping Pong, a pizza parlor in Washington, D.C. QAnon proponents believe that President Trump was recruited by top military generals to run for president in 2016 to break up the cabal, disrupt its control over world affairs, and bring its members to justice. They similarly believe, without evidence, that President Trump was elected to defeat a purported cabal of cannibalistic pedophiles in the government. QAnon supporters also claim that organizations funded by the Bill and Melinda Gates Foundation engineered, patented, and weaponized the novel coronavirus COVID-19 to undermine President Trump's chances of re-election in 2020. Appellant's now ex-wife, Dory Gallagher, testified that appellant's employer at ERA One Source Realty, Miss Sunita Arora, instructed appellant to discontinue his QAnon social media videos and informed him that it wasn't something that she could have in her business. So she didn't say the article. She said, stop making these Q videos. We can't have this around the business. Okay? 4, however, by order dated January 18, 2023, Judge James A. Gibbons approved the party's stipulation in which appellant specifically agrees that for purposes of litigation, plaintiff Phil Godlewski shall be deemed a public figure. So Phil tried to go back and say he's a private figure, and they said, no. You already came out. I remember bringing this up. He just came out and admitted it. Typically, the Scranton Times would have to go through and show why he's a public figure, which may not have been that hard with the following he has, and he says he's broadcasting to millions of people. We know that's a lie, but that we go off his claims. How open he is about being QAnon adjacent, and the Trump administration, all that stuff. But Phil didn't even make him do that. He just came out and admitted it right off the bat. Yeah, I'm a public figure. Third, appellant alleges that Kelly and the Scranton Times defamed him by referring to him as a purveyor of poison, despite not having one whit of evidence that appellant's views and opinions have irreparably damaged anyone. He contends that despite stating that appellant was not at the Capitol on January 6, 2021, the date of the insurgency, Kelly and the Scranton Times tab appellant as not only a supporter, but an active participant and organizer who was integrally involved in the unlawful assault on the Capitol and is part of the conspiracy to overthrow the United States government by force and is thus a seditionist. Appellant submits that by implying that he was an integral part of the Capitol insurgency, the article labels appellant not just as a seditionist, insurgent, and a traitor to this country, but also a murderer complicit in the deaths of 5 persons. Phil believes that no one died at the Capitol, so I don't know why this is even in there. Upon completion of discovery, appellees filed a motion for summary judgment asserting that appellant had failed to adduce sufficient evidence to satisfy his burden of proof as a public figure for his defamation and false light claims. Specifically, appellees argued that appellant cannot establish that any factual statements concerning him in the article are false. Again, appellees argued that Scranton Times argued that Phil cannot establish that any factual statements, including the one that says he got this charge for having a sexual relationship with a 15-year-old, he cannot establish that any of these statements concerning him in the article are false, and that any other non-factual content in the article constitutes either parody or Kelly's opinions and are not actionable. Appellees further claimed that they were entitled to judgment as a matter of law because appellant cannot prove that any allegedly false statement was published with actual malice. So that's on top of it. Not only can he not prove that they're false, but even if he could prove that they were false, where's the actual malice? Or that appellees either knew the statements were false or acted with reckless disregard as to whether they were true or false. In support of the motion, appellees submitted numerous exhibits, including depositions from appellant and Kelly, among others, and affidavits from Bree, the 15-year-old, right? The minor appellant was charged with sexual offenses against and the assistant district attorney associated in that case, Patricia Lafferty. In her affidavit, Bree informed the detectives that she had been in a sexual relationship with appellant when she was in high school, when she was a high school student, and he was the baseball coach at the high school. The summary judgment record reflects that on July 9, 2020, Detective Michelle Mancuso and Detective Justin Leary filed an affidavit of probable cause seeking the filing of criminal charges against appellant based upon his unlawful sexual activity with a minor, Bree. Commonwealth v. Godlewski, number 10, CR 2613, Lackawanna County. Bree informed the detective Mancuso that she had been involved in a sexual relationship with appellant Phil while he was a baseball coach at Riverside High School in 2008, when she was 14 years old and a 9th grade student at Riverside High School. She further stated that they were involved in oral and vaginal sexual intercourse, which started happening in his vehicle in 2008. Bree advised Detective Mancuso on July 7, 2010, that appellant had been contacting her while he was at work as a realtor, and that she has been keeping in contact with Phil through a throwaway phone he keeps with him while at work. He had a burner phone, so Dory didn't find out. After the cell phones and computers of Phil were seized and subject to forensic analysis by Corporal Derek Fozard of the Pennsylvania State Police and Detective Justin Leary of the Lackawanna County District Attorney's Office. The investigators just ascertained that the text messages between Phil and Bree contained conversations of sexual encounters, exchanges of gifts, and brand new vehicle for the victim. Specifically, Corporal Fozard and Detective Leary were able to verify and authenticate the following text message transmitted from Phil to Bree. I just want you to see that I really care about you and not your body or our sex. Maybe that's the only way I can. The only way we'd ever be sexually satisfied is if we did it 4 to 5 times a day. I hate my penis. I don't know why the fuck that happens. You look so good, and we're giving incredible head, then boom, gone, like what the fuck. Realize that you're only 15, but quickly stop caring. I pulled your hair from my crotch area, haha. Should we get a jacuzzi suite? The Commonwealth filed a criminal complaint in case number 10 CR 2631 on July 9, 2020, accusing an appellant of numerous sexual offenses against a minor. Following plea negotiations, the Commonwealth filed an amended criminal information on November 8, 2010, charging an appellant with a single count of corruption of minors on the factual basis that he did. This is every time I made a meme or a screenshot or some type of graphic about this, I always highlighted this. He did repeatedly have inappropriate text messages and contact with a minor. Even if he says, oh, you're not looking at the information, you're looking at the charging documents. In the information, forget the text message, did have inappropriate contact with a minor. Now, this contact is not phone calls, or would have said phone calls like I said text message. This is physical contact, inappropriate physical contact with a minor. On July 11th, 2011, appellant Phil pled guilty to corruption of a minor and was sentenced to 3 to 23 months of home confinement and prohibited from having any contact with Bree during supervision. The court conducted oral arguments on appellee's motion for summary judgment on August 19, 2024. At argument, appellees explained that because Phil brought the action against a media defendant, he bore the burden of proving that the publications were false and were published with actual malice. The Scranton Times claimed that the evidence produced by Phil failed to meet his burden to prove that the Scranton Times made false statements about Phil in the article. Specifically, the Scranton Times argued that Phil cannot, as a matter of law, prove that the statements regarding Phil having sex with a minor were false, especially given his guilty plea in case number 10, CR 2613, where he pled guilty to corruption of minors, nor could Phil meet his burden of proving that the complained of statement was published with actual malice. So not only can you not prove you didn't have sex with her after you took this guilty, as a matter of law, not you don't have a good argument, you don't have the right, as a matter of law, you pled guilty to this, so now you cannot come back and say it didn't happen. Scranton Times further argued that the statements in the article about QAnon and Phil as a purveyor of poison were Kelly's opinions and could not be the basis of a defamation action. Finally, Scranton Times argued that the cartoon was a parody based on Phil's job as a realtor and his broadcasting QAnon conspiracies. On August 30th, 2024, the trial entered an order granting appellee's motion for summary judgment. The court docketed an order on September 3rd, 2024, directing that judgment be entered in favor of the Scranton Times. On September 13th, 2024, Phil filed a timely motion for reconsideration, alleging that the trial court erred in its conclusion that the record lacked clear and convincing evidence that Scranton Times knew that the statements were false or entertained serious doubts about the truth of publication. Phil also challenged the court's observation that the deposition testimony of the Scranton Times editor, Lawrence Holeva, I thought it was always Larry, Lawrence Holeva, was difficult to decipher due to extensive redactions. Phil stated that the counsel had highlighted the deposition and that the highlighting appeared as redactions. So they used a highlighter and then faxed shit in, and that blacks out shit instead of highlighting it a lot of times. Hence, he provided the court with a clear copy of the deposition of Mr. Holeva and requested that the court reconsider its decision. On September 30th, 2024, the trial court issued an opinion denying the motion for reconsideration. The court explained that Phil was bound by the statements made during his guilty plea colloquy, and that, even considering the unobscured deposition transcript, Phil failed to adduce sufficient evidence of actual malice necessary to support his claims. You are bound to your guilty plea colloquy, which said you had inappropriate contact with a minor. Thus, the court stated that it appropriately considered the evidence and text messages from his guilty plea at case number 10 CR 2613 and denied Phil's motion for reconsideration. This timely appeal followed. Phil raises two issues on appeal. One, whether the trial court erred in granting Scranton Times' motion for summary judgment as to Phil's defamation claims. And two, whether the trial court erred in granting Scranton Times' motion for summary judgment as Phil's false light invasion of privacy claim. Our standard of review of an order granting summary judgment requires us to determine whether the trial court abused its discretion or committed an error of law. Judicial discretion requires an action in conformity with law on facts and circumstances before the trial court after hearing and consideration. Consequently, the court abuses its discretion if, in resolving the issue for a decision, it misapplies the law or exercises its discretion in a manner lacking reason. Similarly, the trial court abuses its discretion if it does not follow legal procedures. Then it has some some case law, right? In reviewing a trial court's grant of summary judgment, we apply the same standard as a trial court, reviewing all evidence of the record to determine whether there exists a genuine issue of material fact. We view the record in the light most favorable to the non-moving party, and all doubts as to the existence of a genuine issue of material fact must be resolved against the moving party. Only where there is no genuine issue as to any material fact, and it is clear that the moving party is entitled to a judgment as a matter of law, will summary judgment be entered. All doubts as to the existence of a genuine issue of material fact must be resolved against the moving party. Motions for summary judgment necessarily and directly implicate the plaintiff's proof of the elements of a cause of action. Summary judgment is proper if, after completion of discovery relevant to the motion, including the production of expert reports, an adverse party who will bear the burden of proof at trial has failed to produce evidence of facts essential to the case of to the cause of action or defense, which in a jury trial would require the issues to be submitted to a jury. In other words, whenever there is no genuine issue of any material fact as to a necessary element of the cause of action or defense, which could be established by additional discovery or expert report, and the moving party is entitled to judgment as a matter of law, summary judgment is appropriate. So basically, like if you don't even meet the tenets of this case, and there's no doubt about it, it's not something like, oh, well, that's up for the jury to decide whether it meets. Like you don't meet the tenets of this case to even bring this case, summary judgment is the way to go. You don't have a case. It's not like we think if the jury heard your case, they might side with it. You don't even have a case. You didn't meet the basic minimums to have a case. Thus, a record that supports summary judgment either one shows that material facts are undisputed, or you can't dispute the fact that there was actual malice, and you can't dispute that it was false, or two, contains insufficient evidence of facts to make a prima facie cause of action or defense. Upon appellate review, we are not bound by the trial court's conclusions of law, but may reach our own conclusions. So they're not bound by the conclusion. They reach their own conclusions when the appeal happens. Now we're going to go into a bunch of case law. In determining the existence or non-existence of a genuine issue of material fact, courts are bound to adhere to the rule of Borough of Nantiglow v. American Surety Company, blah, blah, blah. The party moving for summary judgment may not rely solely upon its own testimony or affidavits or depositions. Again, Phil tried this. He kept saying, wait till I get in front of the jury. You can't rely only on your own testimony. There has to be some fact here of some sort. In his first issue, appellate claims that the trial court erred when it granted summary judgment in favor of Scranton Times on the cause of action for defamation. Phil's issue contains multiple subparts, which we must consider individually. In the first subpart, Phil asserts that the court erred in the finding that he failed to adduce sufficient evidence of the falsehood of the statements. Phil argues that the court erred by relying on the doctrine of collateral estoppel when it found that Phil was bound by the statements he made during his guilty plea colloquy. Phil submits that pursuant to Nantiglow Supra, the court's summary judgment determination could not rely on the affidavit of probable cause for that case. Phil claims that the court erred in taking judicial notice of the facts alleged in the affidavit of probable cause in that case, and suggests that because he denied those facts, they did not form the basis for his plea. Phil insists that the trial court was only able to consider that he pled guilty to a corruption of minors charge as evidenced by the criminal information and guilty plea colloquy for his case. Accordingly, Phil concludes that the court erred in considering this evidence and in deciding that there was no genuine issue of material fact regarding the falsity of the statement at issue. We disagree. So this has nothing to do with malice. They're saying we disagree. To establish a cause of action for defamation, the plaintiff has the burden of proof regarding the following elements: the defamatory character of the communication and its publication by the defendant. 3, the application to the plaintiff. 4, the understanding of the recipient of his defamatory meaning. 5, the understanding of the recipient as it is intended to be applied to the plaintiff. 6, special harm resulting from the plaintiff from its publication. 7, abuse of a conditionally privileged occasion. If this is from Lewis v. Philadelphia newspapers. If a statement in question bears on matter of public concern, or the defendant is a member of the media, First Amendment concerns compel the plaintiff to prove, as an additional element, that the alleged defamatory statement is in fact false. To prevail on the defamation claim, plaintiffs as public figures must prove by clear and convincing evidence that the allegedly defamatory statements were false and that defendant newspapers either knew they were false or recklessly disregard for their falsity. Whether a communication can be construed to have a defamatory meaning is a question of law for the court to determine. Cash Dollar v. Mercy Hospital. A communication is considered to be defamatory if it ascribes to another conduct, character, or a condition that would adversely affect his fitness for the proper conduct of his proper business, trade, or profession. Additionally, the court could consider the effect of the statement would fairly produce or the impression it would naturally engender in the minds of an average persons among whom it is intended to circulate. Furthermore, generally, an individual who pleads guilty to a crime is bound by that conviction and cannot collaterally attack or deny his criminal acts in other legal proceedings. That's from the Department of Transportation v. Mitchell, holding that guilty plea established liability in civil case arising from the same facts. So once you're guilty in criminal court, when you go to civil court, you can't say, no, I'm not guilty of that. Instantly, the trial court concluded that Phil failed to produce evidence proving that the statement that Phil had a sexual relationship with a minor was false. The court agreed that under Nantigo Supra, the party moving for summary judgment may not rely upon depositions or affidavits of its own witnesses to establish the non-existence of genuine issues, but noted that the moving party may rely on the testimony of an adverse party. So they're not relying on their own test. They're not relying on Chris Kelly's testimony. They're not relying on the Scranton Times testimony. They're relying on Phil's testimony when he pled guilty. During his guilty plea hearing before Judge Vito P. Gorello on November 12, 2010, Phil expressly acknowledged that he signed and initialed that written guilty plea colloquy and read and understood the answers truthfully, all questions in it. Prior to accepting Phil's guilty plea to corruption of a minor, Judge Gorello directed his assistant district attorney, Patty Lafferty, Esquire, to provide him the facts supporting the corruption of minor charge against Phil. Assistant District Attorney Lafferty stated, between January of 2008 and July of 2010, Phil corrupted or intended to corrupt the morals of any minor less than 18 years of age. In that, Phil did repeatedly have inappropriate text messages and contact with a minor. After Assistant District Attorney Lafferty recited those facts, the following exchange transpired between the judge and Phil. The judge said, and you admit that between January of 2008 and July of 2010, you engaged in conduct just described by the district attorney. Phil, yes, Your Honor. Judge, all right, we'll accept the guilty plea. We'll defer the imposition of sentencing pending the pre-sentence investigation. Phil's counsel, thank you, sir. The trial court further explained that Phil's counsel conceded at the time of oral argument on the motion for summary judgment that the corruption of minors count in the complaint was consistent with the information in the affidavit. The court continued that while the memorandum and order of August 30th, 2024 used the wording, Phil was collaterally estopped from disputing his participation in a sexual relationship by virtue of his guilty plea to inappropriate text messages and contact with Bree, the doctrine of collateral estoppel and its 5 elements were never cited or expressly applied in the process. Nevertheless, Phil's guilty plea is an admission of facts averred in the complaint and conclusive proof of wrongdoing for which he was charged. And that summary judgment could be granted on that basis. So they're not even got to the malice yet. And they're saying, just with this, just the fact that he pled guilty to the corruption of minors and then claims he didn't have a sexual relationship with her, with Bree, that right there is enough. That's enough. That's it. That's all we needed. And Phil claims it's only on the malice portion. It's not. Before they even got to the malice, they're like, nope, you already fucked up. And that the summary judgment could be granted on that basis. Those conclusions stemmed from the defenses asserted by Kelly and the Scranton Times in their pleadings and the summary judgment motion that the factual statements in the article on February 14th, 2021 are true or substantially true and constitute a fair and accurate summary of the statements made in legal court filings. And that Phil's guilty plea was tantamount to an admission of a sexual relationship with Bree based upon the only inappropriate text messages quoted in the affidavit of probable cause. So Phil can't just say, I pled guilty to sending her text messages, because the text messages are all about having sex with her. So the guilty plea to corruption of minors is the exact same thing as saying he had a sexual relationship with Bree when she was underage. That's it. Full stop. The court further explained that the, with Bree based on the quoted being their sexual activity. Okay. The court further explained that the only inappropriate text messages contained in the case file were those which were quoted in the affidavit of probable cause and distinctly acknowledge and describe Phil's sexual relationship with a minor, Bree. Our review of the record supports the trial court's conclusion that Phil did not meet his burden of proof establishing the falsity of the statement that he had sexual relations with a minor. Rather, the evidence reflects that Phil pled guilty to sending inappropriate text messages to a minor, and in those messages, Phil admits to his sexual relationship with a minor. As such, we agree with the trial court that Phil failed to adduce sufficient evidence establishing a genuine issue of material fact concerning the article statement that Phil pled guilty to corruption of minors and admitted to having a sexual relationship with a 15-year-old girl. So the court is saying it is true. We agree that Phil pled guilty to the corruption of minors and admitted to having a sexual relationship with a 15-year-old girl. As Phil cannot prove the falsity of the statement, he cannot meet his burden of proof to establish a cause of action for defamation. Done. In the second sub-issue, Appellate argues that the court erred in finding the statements concerning Appellate's employment as a realtor and his involvement in January 6th insurrection were a parody. Appellate's claims, blah, blah, blah. None of this is important. This is all about the parody, and they upheld everything. The part that's important is the court ruled, okay, we agree with the trial court that Phil failed to adduce sufficient evidence establishing a genuine issue of material fact concerning the article statement that Phil pled guilty to corruption of minors and admitted to having a sexual relationship with a 15-year-old girl. As Phil cannot prove the falsity of this statement, he cannot meet his burden of proof to establish a cause of action for defamation. Now, the next part is about parody. He loses that as well. Rabbit holes is often employed in describing QAnon movement. There's a bunch of the QAnon movement. The record supports the trials court determination with respect to the cartoon with the unrealtor sign and description of appellate selling rabbit holes. We agree with the trial court that rather than factual statements, they weren't factually saying you sell rabbit holes. The depiction and statements constitute parody, which is protected by the First Amendment and cannot form the basis of a defamation cause of action. In his final sub-issue, appellant's first question presented, appellant contends that the trial court erred in finding he failed to present sufficient evidence that Scranton Times acted with actual malice. That's on top of the cake. Of course, he didn't prove any actual malice. We iterate that under Pennsylvania law, where the plaintiff is asserting a defamation cause of action as a public figure and allegedly defamatory statement relates to the matter of public concern, the plaintiff has an additional burden of proving that the defendant made the false and defamatory statements with actual malice. of course, he never met that either. The actual malice requirement is not met through showing of ill will or malice in the ordinary sense of the term, or the failure to investigate even with a reasonably prudent person would have done so. Rather, actual malice requires at a minimum that statements were made with reckless disregard for the truth. That is, the defendant must have made the false publication with a high degree of awareness of the probable falsity. Or so it's not like they have to know it's false, but they have to say, it's really hard to bust people on this. They'd have to be texting like somebody and say, I know this is bullshit or probably bullshit, but I don't care. Fuck him. But of course, Phil had none of that. Instantly, the trial court concluded that Phil failed to prove through clear and convincing evidence that the Scranton Times acted with actual malice. As the court noted, the only evidence submitted by Phil in supporting of actual malice claim consists of the deposition transcripts of Kelly and the Scranton Times executive editor Holeva. Kelly testified that in preparing for the article, he reviewed the Times Tribune archives, including earlier articles about Phil, authored by Jeremy Burton and Dennis O'Malley, legal documents, court documents, the criminal affidavit, and his guilty plea colloquy, and also interviewed relevant witnesses, including Sierra O'Malley and an individual who was in the law enforcement process involving the criminal charges against Phil. The court further explained that after reviewing the unredacted deposition testimony from Mr. Oleva, the editor at the Scranton Times, it found that the complete testimony simply references a columnist's ethical obligations and journalistic responsibility. Oleva's testimony is devoid of any indication that Kelly or the Scranton Times, they thought they had flipped Oleva on when he's just like, they should review, the charging document and the guilty plea colloquy and the information. And Kelly, when he testified, said, I don't know if I reviewed something called the information. Like, I don't know. The record supports the trial court's determination. Phil had the burden of proving actual malice by clear and convincing evidence standard, and Phil failed to identify any facts or evidence establishing actual malice by Kelly or the Scranton Times. Phil's argument provides examples of other research or examinations that Kelly should have undertaken in his investigation of the article, and notes that Kelly discussed with his editor whether he should include portions of the article. However, actual malice is not established by failure to investigate, or even the fact that a publisher could have employed a higher degree of journalistic responsibility. Here, Phil has not provided any evidence that Kelly had a high degree of awareness of probable falsity in the article, or that Kelly entertained any serious doubts about the truth of the publication. Therefore, we agree with the trial court that Phil cannot prove that the Scranton Times acted with actual malice necessary to establish his defamation claim, and the trial court did not err in granting summary judgment in favor of the Scranton Times. Accordingly, we affirm. Order affirmed. Boom. That's it. That's all. Phil cannot no longer hide from this. It's done. He admitted to having a sexual relationship with a 15-year-old while he was a high school baseball coach. He can't deny it anymore. He's not going to take anybody else to court. This isn't going to go to the Supreme Court so they can tell him he also had a sexual relationship with a 15-year-old. It's done. It's over with. He's not, I don't know what the fuck he's saying. So we'll go back one more time. And again, the court agreed. You pled guilty. You cannot come back and say, I didn't do that. You pled guilty to these text messages and contact. Even if you want to argue that the contact was non-sexual, the text messages are only about sex with the victim. So here we go. One more time for the people in the back. This is from Shack to the Future. Here is Phil again. You see if this lines up with what actually went on in the court.
You're going to see me down here, but you're going to see the presentation up in the screen. A couple announcements to make before I get into that. I have been denied in the Supreme Court of Pennsylvania with my lawsuit against the Scranton Times. And although my lawsuit was the appeal, that was the appeal, of course, to get it out of Lackawanna County and into the Supreme Court. The appeal, of course, was to the higher court, the Supreme Court of Pennsylvania. And although I lost, and I'm not going to be recovering anything against the Scranton Times. Now, I could take this another level higher. I'm not going to. But because the manner in which I lost, I'm okay with. They didn't confirm the Lackawanna County's ruling They simply said there's no malice, meaning the writer of the article, Chris Kelly, has to purposely say the things he did while knowing they were untrue. That's called malice. When you're a public figure such as I am, you have to prove malice. The Supreme Court said there's no malice here. So technically I lost on a technicality, but not because what the writer said was true about me. To me, although it's not a victory, it's a acceptable outcome. I am not going to pursue anything further against the Scranton Times. I am considering dropping my lawsuit against Nick Albeer.
This has handed a win to Bree.
Just because I don't want to deal with this shit anymore.
The last update we have on Bree's case was from 5/16/2025, which was defendant's brief in opposition to plaintiff's application for amendment of order. Defendant's response to plaintiff's application for amendment of order. It's just a bunch of amended, but this is a win for Bree. Like, she's not going to lose.
And we'll see what happens with the other couple. I know you guys don't want to talk about lawsuits tonight because we have a lot more important things to go.
This also basically hands a win to Pebbles, right? Phil is claiming that, so the countersue. Phil's countersuing because she called him a pedophile, or he claims that she called him a pedophile. I don't know about the doxing and all that stuff. Hopefully she wins on that too, because this was all triggered from her saying, "You piece of shit. Like, you're out here fucking 15-year-olds. Like, what are you doing emailing me and doxing me and shit?"
And talk about, but the court system in this country is terribly flawed.
It's the court system.
Terribly. I mean, terribly. I mean, you saw
everybody that's looked at this case from beginning to end, except the lawyers that Phil was paying tons of money to do nothing, apparently, to everybody that's in this case from start to finish has says Phil has no case. But now it's the court system's flawed.
saw what Trump went through. I just went through something very similar, and it's a joke.
Him and Trump, baby.
Joke. There is no justice when it comes to the media. There's just not. And I really hope that
especially when you already pled guilty to a sexual relationship with a 15-year-old, and then they report exactly that.
Trump can fix this, and it appears that he's, taking out the media every time we look around.
And shout out to the Scranton Times and their legal team and Chris Kelly. They could have easily fucking played this off or been like, "How much money you want? You want a retraction? Whatever. We don't want to spend fucking 4 years in court."
By the way, before we get into the Charlie Kirk stuff, Jimmy Kimmel's fired. Matthew Dowd fired. These are big things that are happening in the media, which is awesome. Absolutely awesome. So
there you go, guys. That is Phil Godlewski in a nutshell. Completely stopped from denying that he had a sexual relationship legally with a 15-year-old. He cannot say that anymore, and multiple courts have affirmed it. Too bad. You already admitted guilt. If you like the show, if you want to support the show, that's it for tonight's show. I want to keep it separate. I want you guys to share this to people who know about it, who know about Phil or whatever. It's done. It's over with. He can't keep playing it and saying, "Oh, well, it was just a malice. I could prove their statements are false, but I couldn't prove the malice." He proved nothing, and the court knew it from the beginning. Even without the malice portion, the court ruled that he already lost the case with his guilty plea. He already pled guilty to this. You can't take that back and say, "Oh, no, the contact was phone calls where we just talked about Jesus." No, it was sexual contact that's included in the text messages where you're talking about your sexual contact. Thank you guys for joining us. If you want to support the show, do it at buymeacoffee.com/coldbeer. I'm out of here tonight. I got to go home early. I got an appointment in the morning to get new tires put on Mariah's car before she goes out of town. Thank you guys for joining us. Thank you for being here. I'll see you about the next one. Share it to the Phil lovers in your family or in your lives. You guys have a good night. We'll see y'all later.
But I can tell you this.
Short, sweet, and hopefully some of his followers will actually watch it because it's not 2 or 3 hours long,
To call out the people on this planet by name and tell them exactly who they are and tell them the rest of the world who they are. You don't have the forking balls. You don't have the balls.
Okay, Scott.
Here we go, I think I started some shit. Piss 'em off, it's about to get lit. Get the place in the best, you know that stage is set. You better buckle up, cause you ain't seen none yet. Here we go, I think I started some shit. Piss 'em off, it's about to get lit. Get the place in the best, you know that stage is set. You better buckle up, cause you ain't seen.
Oh yeah, happy Rapture tomorrow, guys. I'll still be here, so if you guys are gone,
Sense for the stupid shit.
I don't know. I guess have a fun trip.
Praise the Lord.
I'm not getting sucked off by God tomorrow.
Profit to profit.
For somebody else.
Worshiping drums, cocking, begging for a throat deposit. Swinging fucking meat hammers like four in a thong. He's strapped to the shaft, eating his chest like he's King Kong. Starving for attention, I'ma make your gut burst. I'll be your huckleberry, I can quench that thirst. Baby eating lizard people, alien sex. What's next? Trump in a dress, fucking Flynn on his desk. A retard in a vest,
To be fair, you guys might be leaving in just a few minutes. What, 10 minutes or something?
Here we go, I think I started some shit.
Make sure your bags are back. I watched a lady that laminated Bible verses and explanations of what happened and has been spreading them around her community for the last week in preparation for getting sucked off by God tomorrow. Everything's on Eastern time zone. You know that. We're the only people that matter.
When I was high on shrooms, I found myself a tunnel that led to Jason Q's bedroom. Open his closet.
So basically, she would like highlight like what it would say in big letters in like a flashcard, what happened, and turn it over. And she laminated these cards, and it said the rapture, and it had a Bible verse and what you should do and how you can meet Jesus. And she was been spreading them out, like hiding them in bushes and shit.
What? I'll get my files. What are you doing? Stop. Fucking stop. Dude, come on.
If a single one of them really believed any of this, why didn't they go and donate all their worldly possessions, sell their home, donate all their money, and just be sitting around right now? They could have gave me their home. I'll be here. I can use it. Right? When you get sucked off by God, what do you need your home for? Or your savings? Or your Tesla? I really do want a Tesla still. Good night, guys.
You better buckle up, cause you ain't seen none yet. Round 3. Down goes Nino. Please say it isn't so. Got